Hello, I'm Angela Princeville, and now I have Andrina Minicosi and Brendan McDermott, and we want to talk about access, particularly grandparent access. Andrina here is actually, we call her our resident expert on grandparent access issues. She's done various motions on this matter. She's represented lots of clients. She actually has reported decisions on the matter. Brendan is a great family law lawyer. He's a father, and his position today is opposite of Andrina's. He's saying that grandparent access should be subordinated to the parents' wishes, and he's actually relying on Section 20 of the Children's Law Reform Act for that entrenches the parents' entitlement to custody. And so I'm going to let him and Andrina go. Again, remember, this is not their permanent positions. They're just taking these positions for purposes of argument today, and they haven't heard each other's arguments, so this is all going to be raw and fresh. And would you want to get started? Andrina, why don't you go? Why do you think that grandparents should be entitled to a lot of access, generous access, I should say?
Thank you, Angela. Basically, why grandparents should have, in general, access to the children is because, as you know, children spend time with the parents, but a lot of the times on the weekends they spend with the grandparents. If the grandparents, and now I have had cases where, for example, parties suddenly deny full access to grandparents, giving no reason to such denial. Then I also have cases where the grandparents have had access to the children, and in fact they're the ones that have taken care of the children for several years because their parents by various motive have not been able to be raising their own children. So the cases that we will be talking today, I'm going to be talking about cases where one of the grandparents was fully taking care of the child since the beginning, since she was 2 years old up until now she's 7, and what had happened when we went to court. And then I also have right now a new case where a grandmother was denied access suddenly after 2 years of a status quo, seeing the grandchild every Sunday.
Okay, now this topic, is this something that would apply in the context of a separation, or is this something that could also arise while, I guess, the relationship, it's probably in the context of a separation, right? Because if the parties are together, this is something they would probably work out, or maybe not necessarily so.
Yeah, I think there's three situations when grandparents gaining access or even custody arises. It can be two perfectly healthy, caring parents where the grandparents just feel like they've been set aside or not included in the child's activities on whether it's a day-to-day or a week-to-week basis, month-to-month, who knows, depending on what their personal feelings are on the matter. There's also a situation where there's separation, and obviously that builds a lot of tension, a lot of difficulties, because parents are quite obviously going to be focusing specifically on their child's needs in that situation, so they can be biased in their opinions, which makes it difficult as well. And then there's situations, where one spouse has passed away and there's only one child left, and maybe you have that opposing mother or father-in-law that feels, they want to get involved. So those are a few of the subjects that I'll be touching on.
Absolutely. Okay. So what's the reason for your position?
Well, first and foremost, my position is based around the fact that obviously I love grandparents and I see how important they are in a child's life, and how they build and influence their grandchildren as they grow up. They have the history and the knowledge to really help them improve. But the point of the law that's in place right now currently is it's not means of a punishment towards grandparents. It's more of a preventative measure to ensure that it is the best interest of the child. I've got a few factors here that I can touch on.
Okay.
In terms of, reasons why the law, it is slightly changing a bit to recognize grandparents a little bit more, but they're very preventative in the sense that they want to ensure that grandparents aren't unwillingly or just deciding to step in based on their own personal feelings. They want to make sure that they're giving parents that autonomy that they deserve. I mean, the case law states specifically that you want to give parents that autonomy for good reason. Like you said, a good example is maybe these grandparents or one specific grandparent has been with the child or children for weeks at a time. Seems to be the primary caregiver. But the law's in place to give parents that opportunity, because you don't know. Maybe there's an individual parent that's trying to better their career or trying to better their personal life through relationships, and they need kind of that extra time the grandparents have benefited. Yes, the grandparent feels that once that dynamic changes and the parent wants the child more part of their life, that they want to step in and say, hey, no, this is the way it goes. Unfortunately, the law protects them in that case. Another example is...
The law protects them in that way. Sorry.
Protects the parents in
So
that
yes,
sense. Go ahead.
So can you expand on that? Because I don't believe if you're saying, I understand you need to be more specific when you're trying to say that if you put your children to be taken care by a grandparent, so you have to go to work, that's like a daycare kind of situation. So you can actually put the claim that if you didn't want to have the children taken care of by the grandparent, then you should have put them in daycare.
Yeah,
So
I think what Brendan is saying is and correct me if I'm wrong. So this grandparent has stepped in and helped when the children needed it, but he's saying sometimes there might be a scenario where the grandparent now feels like they know what's best for the child, and he's saying that they should not overstep, and that the parents are the primary parents, and maybe the law is there to prevent grandparents from overstepping. Does that kind of...
Yeah, absolutely. Obviously, emotions take the biggest play in this situation, and I can see how a grandparent, let's say, spends months or even years with a child while maybe one individual parent is doing something. We don't know the details of that parent, if they're trying to focus on work or personal life, or maybe they're dealing with an addiction or they're incarcerated, something along those lines. Mm-hmm. And then that parent has turned their life around and they come out and the grandparent says no.
So
I still want to have access to the child.
And that's a great example, because so one thing that you need to bear in mind is that we're thinking about the children. We're not thinking about the parents. We're not thinking about the grandparents. So when law comes into play, we're thinking only about what is in the best interest of the child. I do know that you're going to be talking about Section 20. I'm going to be talking about Section 24. But when we're thinking, Section 24 only deals with what is in the best interest of the child. And when we look at that, we look at several factors. We look at love and affection, emotional ties between the child. We look at child's views and preferences. If the child is too young, you may not be able to ascertain those kind of preferences, and then you may get an OCL involved. If that's the case, sometimes it's not needed. You see the length of time that the child was with the grandparents. I had a case where the father was incarcerated for about 2 years, and then the father believes that he can just come out of jail, whatever it is. I'm not judging anybody, but the sole responsibility has been with the grandmother. As soon as he was incarcerated, she was called by a CAS to take care of the matter, take care of the responsibility of taking care of this child. Then now he was getting access every single weekend. So it's not about the fact that the grandmother didn't know that as soon as the father was out, let's see, probably he's turning his life around. I don't know how long it will take this person to turn this life around. Regardless of that, the child have had a status quo, as a certain standard of living with this grandmother. So suddenly you're detaching that child from that environment and putting her to a new set of rules and new set of environments, a new set of school, new friends. Everything is going to be different. So you need to think about what exactly is happening mentally to that child, because that child already lost the father one time. You don't want that to keep happening.
Okay, so Andrina, I know that this almost, and when I think about this, it almost sounds like I shouldn't, because you're trying to keep us to the child. But I still can't help thinking, is the father being punished twice? So he's been incarcerated and he's done his time, and now he's going to, I don't know if he's been punished or he needs to go through another rehabilitation before he gets to spend time with his child. Am I understanding this wrong?
Yeah, absolutely. I mean, I am focusing on the subject matter here, and I know that you're very passionate about the details and you're dealing with individual experiences, but I'm just speaking as an inexperienced lawyer who does have an opinion in these matters. I'm also speaking from the law and the way it works, and I look at Chapman and Chapman's case, where they focus on an acrimonious relationship between, let's say, a parent and a godparent, or sorry, not a godparent, but a grandparent, right? A son-in-law, daughter-in-law, things of that nature, right? And the focus there, and I think it relates to your facts, is the sense that the double punishment is a great way to look at it as well, but they come back essentially and they want to make their life better. We don't know why this person was incarcerated, or maybe we do, but we weren't there on the day it happened. We don't know all the facts. We just know how the end result happened and what's been happening in the last few years. So I like that idea of the double punishment, because the way the courts look at it is, it's not that the grandmother doesn't have access automatically. She's allowed to seek leave under the Divorce Act and then make these arguments and these claims. And then the father has the opportunity to prove, he has the upper hand, but he has to justify what has he done in his life, what has he turned around. It is still focusing on the best interest of the child, but it goes automatically to the parent. And the courts have stated they should not be permitted to impose their perception on the children's best interest in circumstances where the parents have provided attentiveness and they can provide needs for the child. So to me that makes sense, because you're essentially letting the parent have first right, and then the grandparent or another third party make a claim for second right. It doesn't completely remove, and the reason why it's important, if I can touch on this just briefly as well, the reason why it's important essentially to kind of have checks and balances in place for grandparents, because you're creating potential floodgates of other scenarios. Your scenario is absolutely right, and I would hate to see a child go into a broken relationship with a parent that is not a good role model or impact on them. However, what about the scenario that if we give grandparents too many rights and they can automatically just apply to the courts due to that acrimonious relationship or a problem that they're having or a view or perspective that they have? What about the possibility of a third party? Let's say a parent that doesn't have any access to his children because he's been restricted by the law, and then he knows that a grandparent has this automatic right to go seek access, and he uses their vulnerability to convince them to go claim that access so he can kind of have a backdoor in.
I think Andrea can speak to that. I seem to remember a case
Yeah,
where she's had
like
where the grandparent wasn't getting enough time. Is it you think it's in the best interest of the child to have generous access to the grandparents in a situation where there is a separation, for example, that's going on, and the grandparent just thinks, I'm not getting enough access because the other party isn't allowing me have enough access? And I know you've dealt with grandparents in situations like this.
Yeah, so unfortunately, I'm very passionate about access to grandparents. I don't believe that denying or restricting the time of access that grandparents should yes, it's a decision that both parents will make, but in terms of when the parties decide to separate, why does the decision to see less the grandparent gonna be affected? So if you make that decision in the get-go, since you guys, both parties were together, why suddenly you're gonna deprive the child from seeing the grandparents in the first place? Now, touching upon one subject that you were saying about Chetman and Chetman, I'm gonna make you see a few cases that you need to consider when we're actually talking about the status quo, okay? So when we're thinking about the status quo, and the status quo, what I mean with that is that when a child has been living with a grandparent, or certain type of access have happened for a certain amount of time, it's really hard to change that status quo, and the courts is actually very reluctant to change that status quo. Now there's percolate and percolate, where they talk about, for example, where a child live with the de facto grandparents for more than 2 years or so. So now we're talking about more than 2 years. So anything that has to do with more than 2 years probably it has to be reviewed as important for consistency and stability for the grandchild. Okay, so when we're thinking about, I remember very much when opposing counsel was at the motion and he was talking for his case about Chetman and Chapman, and that did not fly with the court. So what it fly was, what the judge actually empathized was, what is happening right now with the child? Where does she feel comfortable? Where does she feel stable and secure? And I am not trying to double punish the father. However, decisions were made by the father, and that led to consequences. You have to realize that any kind of decisions related to your children is going to have an effect. And the ones that are stable figures at the time, if they were grandparents or it was the other party, let's say the mother, at the end of the day, they're going to have an upper hand compared to the father. I'm not saying that he needs to be double punished. No, that's not what I'm trying to say. But up until he actually proved to the court and to the child and to the grandmother that he has changed, then something may happen. However, if you do believe that the father, in that case, let's say he's trying to turn his life for the better, why would you, as a father, take away the child and never return the child? Or why would you start a court application when it was the grandmother that actually took care of that child carefully for you? It was your own son or your own daughter, and she took care of everything. So out of grace and gratitude, you should, as a father, think about, why am I bringing you to court in the first place?
Okay, now, and I want to add something here, and I know in terms of Chapman and distinguishing these cases, I'm sure if we give Brendan an opportunity, he would also distinguish your case. That's what you guys do. So you could be here all day distinguishing your case on the facts, and that's the good and bad thing about family law, depending on how you look at it. It's too fact specific, and she could actually even equally turn around and just rely just as well on Chapman when the facts are right. But in terms of the court, I mean, what if a father has no other choice, if he's asking for his child back and the grandmother is refusing, does he have any other choice except to go to court? Because we both know that mediation, you could be there for years and nothing. It's an attempt to resolve the issue, but it's not the same force as an order. So what else could the father have done besides going to court, even though he's extremely grateful to the grandmother?
Okay, so yes, you're very much right. Everything about family law is very fact specific. So if I believe that the first step should be and should always be to ask for greater access by negotiation. So usually when we lawyers get retained, we send intro letters and we basically say, this is what is happening, this is the status of the situation, can you give us further access? If I was representing the father in that case, a scenario, I will say, I understand that every single weekend my client has access from Saturday to Sunday. However, can we extend it to from Friday to Monday morning, and I will do the drop off on Monday morning.
Brendan, as a father, don't you have concerns about this child that you brought to this world, and despite whatever mistakes you have, having to request greater access from the grandmother? Does that rub you the wrong way?
No, I mean, absolutely. Truthfully, Andrew, I know you well, and you're so passionate about your clients that I think in the alternative, if that client came to you, you'd be all over getting that person as much custody and access right off the bat. You're that passionate of a person, you really have that ability to connect with your clients, which is great. And I agree with that sentiment. I mean, I understand we're really focusing on one specific example, and this creates an example where the grandparent has essentially had all access, all custody, all decision-making capabilities, with one parent remaining who's potentially not a good person. But the law is not established to just regulate against that one situation. Mm-hmm. It's an encapsulating thing that's supposed to, guide against multiple situations. And we've spoken about a few of them with regards to, two perfectly healthy, caring parents and that grandparent wanting more access or potential custody for selfish reasons. I mean, the law in place right now, again, is the best interest of the child for good reason. The grandparent still has to satisfy, a certain three-part test, or they've got to show that they have certain relationship benefits that they can provide. They're not acting for their own selfish purposes. I do see in our specific example, and I do like talking about this one because this is the most potentially detrimental to the child, right? Are we willing to let the child leave a grandparent and then go live with, whether the person's an ex-convict or something like that? Maybe they haven't changed their ways. Maybe they have. We don't know the situation. Maybe increasing access, trying to develop a little bit more of a relationship and see how it goes from there. That would be a very lengthy and difficult process, but it may be worthwhile for the best interest of the child. As a father, I just hope I never go to jail and I never have to put my daughter in that position.
I'm going to try to put you as a mother in this case, and this is also, and I'm going to make it very fact specific. So we have a separated couple, and there's custody and access issues. Now you're the mother. There's custody and access issues between the father, and now the father and the mother. Children are residing primarily with the mother, and now paternal grandmother is coming to Andrina requesting help to get more access to the child. Now, as a mother, do you see you're arguing that you should get your access when your son has access? You know, we're no longer together. Do you think you should give access time to the father and also special access time to the grandparent?
Again, I think it's going to come down to that certain criteria that needs to be satisfied. It's dependent on the relationship that grandmother currently if we just focus on the grandmother, not the father, because obviously I think the father has every right to make a claim for access and try to increase their access as much as possible, and the courts are going to look at benefiting both parents because they know how important it is for children to have a connection with both parents. In terms of the grandmother or any grandparent coming in that situation, I believe they should have the ability to kind of make a claim, or dependent on the relationship they currently have with the child. If the child gets along with that grandparent extremely well, they've learned a lot and grown from that grandparent, and it's only really fizzled off, in the last few years or few months, whatever it is. Absolutely. I mean, if this grandparent never had a relationship with the child for whatever reason, I think the court looks at that and they really try to focus on, why was there not a relationship before? Why are you stepping in now? It seems convenient that you're making a claim against your daughter-in-law specifically just while a separation is occurring or there's difficulties. So depends there.
So what do you what do you think about this? Should the grandmother have separate access that's completely separate from what the father has?
Yes, if that was happening before.
So you both agree that it depends on what was happening before.
Yeah, so I need to understand what was happening before in order to, and also that is when I'm having the consultation with any of the grandparents, and I always ask the history because that's important for me to understand their strength in my ability to fight it in court. So because why? The court is going to see the history. They're going to see what had happened before and what has changed that trigger you come into court in the first place.
What I'm wondering is if now there's a separation. So let's say couple together, it's okay to send the kid to grandma during the weekend because during the week we're together. The child's in the home with us. Now there's a separation, and now as a mother, first I have to let them go maybe this weekend to the dad, and now you're asking me to also create additional time for the children to go away and be with the grandmother. Isn't that asking too much of the custodial parent?
Not necessarily, because if you're not the whole idea is that the children also needs to be in touch with the rest of the family. It's not only about father and mother. It has to be grandparents and uncles. So I do believe that it's important for the child to have an equal balance of spending time with paternal and maternal grandparents and uncles.
And you think that's something that the parents should always try to incorporate into whatever they do. Okay.
I think we can tilt that a little bit. I don't feel that situation specifically should occur. I mean, having to inconvenience the mother or the children to go visit two separate parties throughout the week or the month is very difficult. We know how hard it is with one person involved. Is the father getting enough access on the weekends or during the week? I think it's more about, to me, that creates a selfish situation where the grandparent is saying, I want access to the child. I have every right to it. We've established a past relationship. But now, you have to come to me. You have to come to my house and do that. If the grandmother can maybe be included in a parenting plan where it's, the father has the kids these days a week, grandma is welcome to come visit on those dates, something along those lines. I think you can kind of meet it in the middle a little bit more.
Well, thank you guys both for your positions. That was very entertaining, and we'll talk to you next time. Thanks for watching.
Thank you.